Important Bar Rules Series. Evidence.
Relevance. Logical relevance. Evidence is relevant if it has any tendency to make a material fact more or less probable. California requires the fact to be in dispute. Legal relevance. Relevant evidence may be excluded if its probative value is substantially outweighed by the risk of undue prejudice, including confusion and misleading the jury. Proposition 8. In a California criminal case, all relevant evidence is admissible, subject to a few specific exclusions, including constitutional rights, character evidence, and hearsay. Public policy exclusions. Subsequent remedial measures. Evidence of repairs or safety measures taken after an accident are inadmissible to show fault. However, such measures are admissible to show feasibility or ownership. Liability insurance. Evidence of liability insurance is not admissible to prove whether the person acted negligently or otherwise wrongfully. Settlement offers. Discussions and offers to settle a claim are inadmissible to prove the validity of the claim. Plea negotiations. Discussions and offers to plead guilty are inadmissible to prove criminal guilt. However, in California, such statements are admissible under Proposition 8. Competence. A witness must have personal knowledge of the subject matter of the testimony. Lay opinion. A witness may give opinion testimony if it is based on the witness's perception and helpful to the trier of fact. It cannot be based on scientific or technical knowledge. Expert opinion. A qualified expert may give opinion testimony based on specialized knowledge if it is helpful to the trier of fact and based on sufficient facts, reliable principles, and a proper application of those principles to the facts. The FRE applies the Daubert standard, which requires the opinion to be based on reliable principles and methods. The CEC applies the stricter Frye standard, which requires the opinion to be based on generally accepted scientific methods. Privilege. Privilege provides testimonial protection for certain relationships, allowing a witness to refuse to disclose information or a party to block disclosure by the witness. Attorney-client privilege protects confidential communications between an attorney and a client relating to the representation. The client is the holder of the privilege. The CEC protects such information obtained by eavesdroppers. Marital privilege covers two distinct privileges. Marital testimonial privilege protects a witness from testifying against their spouse. The privilege can only be claimed during marriage but covers information learned at any time. The testifying spouse holds the privilege, which can be waived if the testifying spouse wishes to testify. Under the CEC, the privilege precludes the spouse from being called to testify, thereby eliminating the need for the spouse to invoke the privilege in front of the jury. Marital communications privilege protects confidential communications made during the marriage. The privilege survives the end of the marriage and is held by both spouses. Thus, one spouse may prevent the other from testifying, and the privilege remains even if the couple is divorced. Documents. Authentication. The proponent of the evidence must provide sufficient proof that the document is what the proponent claims it to be. Authentication can be established by showing chain of custody, or testimony by a person with direct knowledge. Certain documents, such as certified copies of public records, official publications, newspapers, and periodicals, are self-authenticating. Best evidence rule. CEC. Secondary evidence rule. To prove the contents of a writing, either the original or reliable duplicate is required. A summary of a voluminous document may be introduced through a sponsoring witness. Under the CEC's secondary evidence rule, secondary evidence, such as copies or testimony, may be admissible unless a genuine dispute arises regarding the document's authenticity. Character evidence. General rule. Character evidence is inadmissible to prove conduct in conformity with that character. Character evidence takes the form of reputation, opinion, and specific acts. However, character for lack of truthfulness is admissible for impeachment of a witness. Civil. Character evidence is inadmissible to prove conduct in conformity with that character. However, character evidence is admissible where character is at issue. Rape shield laws prevent evidence of a victim's prior sexual activity from being admitted. Criminal. Character evidence is inadmissible to prove conduct in conformity with that character. Defendant's character. If the defendant opens the door by presenting evidence of a pertinent character trait, the prosecution may rebut. In addition, the prosecution may present character evidence of the defendant's propensity in cases of sexual assault or child abuse. The CEC also allows such evidence in cases of domestic or elder abuse. If the defendant offers evidence of the victim's character such as violence, the prosecution may present character evidence of the defendant's same character. Victim's character. If the defendant opens the door by presenting evidence of a victim's pertinent character trait or by claiming self-defense, the prosecution may rebut. Rape shield laws prevent evidence of a victim's prior sexual activity to be admitted. Form of evidence. On direct, character may only be established by reputation and opinion evidence. On cross, FRE allows inquiry about specific acts, but no extrinsic evidence about the acts is allowed. CEC does not allow a specific act to establish the defendant's character. Admissible non-character purpose. Evidence of specific acts is admissible for non-character purposes including establishing motive, intent, lack of mistake, identity, common plan, opportunity, knowledge, other non-character circumstantial evidence, habit, custom, habit, a usual and regular way of responding to a repeated situation, is admissible to show conduct in conformity with that habit. Impeachment. Bias. A witness may be impeached by showing they have a bias, self-interest, or motive. Sensory defect. A witness may be impeached by showing that they have impairment of their capacity to observe or remember. Contrary evidence. A witness may be impeached by presenting contradictory evidence from another witness. Character for truthfulness. Evidence of character for truthfulness of a witness is an exception to the general rule against character evidence. The evidence may be in the form of opinion or reputation. On cross, specific bad acts may be inquired into, but extrinsic evidence is not allowed and the examiner must accept the answer. Criminal conviction. Conviction of a crime of dishonesty is admissible. A felony conviction is admissible if the probative value outweighs the prejudice. Misdemeanor convictions, not involving dishonesty, are not admissible to impeach. An old conviction more than 10 years old is admissible only if its probative value substantially outweighs its prejudice and the adverse party has been given reasonable notice. Rehabilitating a witness. If a witness's credibility is impeached, evidence of character for truthfulness can be offered. In the absence of impeachment, bolstering is not allowed under the FRE, but it is allowed under the CEC. Prior inconsistent statement. A prior inconsistent statement of a witness is admissible to impeach the trustworthiness of the witness. It may also be admitted substantively for the truth of the prior statement. 1. If it was made under oath. OR. 2. If the witness is subject to cross-examination regarding the inconsistent statement, or if admissible as a hearsay exception. Prior consistent statement. A prior consistent statement is not hearsay and admissible to rebut a charge of recent fabrication or improper motive, if made before the motive arose, and the declarant testifies. Hearsay. Hearsay is an out-of-court statement offered for truth of the matter asserted. It is inadmissible unless an exception applies. Non-hearsay purpose. An out-of-court statement not offered for the truth of the matter asserted is not hearsay and is admissible. Effect on listener. The listener was given notice, information, or experienced an emotion, state of mind, a statement of the declarant's then existing state of mind, emotion, or physical condition is admissible to show intent, motive, or plan. Legally operative facts. A statement that has legal significance. Hearsay within hearsay. When a hearsay statement is embedded within a hearsay statement, each layer of hearsay must have its own independent exception to be admissible. Exceptions, exclusions. Party admission. Statements made by a litigation opponent may be offered against him. An adoptive admission occurs when another person makes a statement, and the party hears, understands, and adopts it through words, action, or silence. A vicarious statement is made by an employee or agent. CEC requires that the employee be responsible for the negligent conduct. A co-conspirator's statement is admissible if made during the conspiracy and in furtherance of its objectives, even in a civil case and without formal conspiracy charges. However, in a criminal case, such statements are subject to the confrontation clause. Excited utterance. A statement made in response to a startling event while still under the stress or excitement of the event. Present sense impression. CEC. Contemporary statement. A statement explaining an event made while or immediately after perceiving the event. Statement of intent, physical condition. A statement of then existing mental or physical condition, including a plan or intent. It does not apply to statements of memory or belief. Medical statement. A statement made for purposes of medical diagnosis or treatment, describing symptoms or cause, is admissible under a hearsay exception. CEC. Only for child abuse. Document exceptions. Past recollection recorded. Past recollection recorded is 1. A written record of an event. 2. Made by a witness with first-hand knowledge. 3. While the events were fresh in their mind. And 4. Accurately reflects their knowledge. And 5. Is admissible when the witness now cannot recall the event well enough to testify fully and accurately. Memory refreshed. A technique that allows an item to be used to refresh a witness's memory when the recollection is uncertain. The witness must then testify from their memory and the item is not admitted into evidence. Business record. A regularly written record made in the ordinary course of business by a person with knowledge. Under the CEC, opinions or diagnoses are not admissible as part of a business record. Public record. Public record is an agency's record of its own activity which records matters observed in the line of duty or duty to report. In a criminal case, the FRE does not allow police observations to be used against the defendant. Learned treatise. Under the FRE, a writing that has been established as reliable by an expert witness may be used as evidence. Under the CEC, a learned treatise is admissible only for facts of general notoriety and interest. It cannot be submitted directly as evidence, but it may be referenced or quoted by a witness to support their testimony. Exceptions when declarant unavailable. A declarant is unavailable if they are deceased or cannot testify due to privilege, incapacity, or cannot be found. Dying declaration. A statement made by the declarant while believing that death was imminent, pertaining to the circumstances of their impending death. Under the FRE, it is admissible in civil cases and criminal homicide cases. Under the CEC, it applies to all cases, but the declarant must die. Former testimony. Former testimony is admissible if the declarant is unavailable. The testimony was given under oath at a prior proceeding, and the opposing party had an opportunity and similar motive to develop the testimony by direct, cross, or redirect examination. Statement against interest. A statement that was against the declarant's financial or penal interest. The CEC also allows statements against social interest.